Good morning, sir.
Good afternoon, Anshuman. How are you?
I'm fine, sir.
Anshuman, please introduce yourself.
Good afternoon, sir. I am Anshuman Rath. I'm from Rourkela. I did my schooling in Rourkela Chinma Vidyalaya English Medium School, and then I did my graduation of BA LLB from National Law University and Masters as well LLM from of Constitutional Law as a specialization in National Law University Odisha as well. Then currently I'm pursuing my PhD from SOA National Law University, so SOA National Institute of Law, and as well as I am a assistant professor currently working at SOA National Institute of Law.
Right. So, Anshuman, I have one doubt that you're already your career seems like it is academics oriented. Then why is it this inclination for judiciary? Why do you want to join judiciary?
So I had joined law as a profession just to do judiciary itself. It is just that my guide and my teachers had suggested me that if I be in this profession as a teacher, then I'll be acquainted with the books, and similarly with the studies if I choose in any other sector. So currently I want to be initiated I want to complete my PhD as well as, and I think that currently academic would be a better option for me while getting into this judicial services. So this is just a time frame which I'm adjusting for judicial.
Tell me what makes you stand apart from the other candidates. Tell me five qualities in you which should be there in a judge, and that's why we should take you as a judge.
Sir, basically, as a judge, it requires immense hard work. So, if I took my current profession as well, so when I am working as a judge, I generally stand out from other candidate as well because our time of working is from 9 to 5, but I work up to 8 p.m. So for me, hard work is not a issue. Secondly, in spite of my health issues, I generally stand out to work for more time to give my best, and I am a quick learner. I learn things quickly. Fourth is I love to do research. So if a topic has been given to me, and generally my PhD topic is related to the prison department, prison administration. So if a topic is given to me, even though I'm not related to it, but I do keen research about it. Simultaneously, coming to the fourth point, what the most important thing for a judge is to be unbiased. So being a person, I think I am unbiased because my professional life and my personal life I try to keep segregate both the things. I try to segregate. And fifth thing is that I love my job, whatever I do, and I will be doing it with my whole heartedly, and I'll give my 100% above effort to this.
What is the job of a PhD holder? I mean, what do they actually do? They do research, I believe.
Sir, basically, from when we start our law profession as a BLB candidate, we tend to read everything little bit. It is just like knowing what exactly wherever it is present. But when we are coming into the PhD category, we first ensure that what exactly present in a particular point of law, and then we analyze that point of law how it is different from the other aspect, and we go deep studying it to find what which is never had been researched or which is never had been thought of exactly. So our dealing is to get into that area which no one has ever thought of or no one has ever explored.
Okay, so to cut things short, yes, it is a job of a research. It is
Yes,
researching and finding out. Okay.
yes, sir. Yes.
So don't you think artificial intelligence does a better job? And so now the job of a PhD holder or researcher is becoming redundant.
Sir, we are researching as a topic in a topic, we basically have a system called hypothesis building. So hypothesis shows that what our bias is. So generally, if I have a bias and if I am working on it, then I will be proving whether my bias was correct or my bias was not correct. So the element of human touch or human intelligence, recognizing compassion regarding my topic is all present, which cannot be given by AI because it is not biased at of it first.
So
So,
that's in fact better because here you are to eliminate bias. You are doing all of this, but
sir,
AI will not have any bias at all.
Sir, biasness is not bad unless and until you are recognizing this bias for a research benefit. For example, if my biasness is that in India, the all women prisoners are having 100% literacy rate. So that is my bias. But when I am researching on it, point by point, step by step, when I'm acknowledging the fact and then coming to a conclusion through the research, that makes me different from AI, sir.
How many types of remands are there, Anshuman, and how are they different
Uh,
from each other?
Sir, remands basically now, as of now, I can recall is basically police remand, sir.
Only police remand is there, nothing else.
Sir, basically, I'm not able to recall as of now.
Okay. What is the evidentiary value of a case diary?
Sir, case diary basically suggests what process whether police investigation was done correctly or not, whether investigation was done in a proper framework or not, whether everything was taken into consideration or not. So that is being checked while checking while checking the intricacies during the trial, sir.
So my question still remains the same. What is the evidentiary value of it?
Sir, evidentiary value basically evidentiary values of sir. I'm sorry, sir. I don't think that we answer able to answer.
Okay. Please tell me that what is the provision that has been given in CRPC about set off?
Uh, what I can recall as of now is in terms of plea bargaining, the setup can be considered, and similarly in terms of compounding of offenses, it can be considered as set-offs.
Not really, but since you spoke about plea bargaining, can you tell me in which country it originated?
Sir, US, sir.
Okay. Whether a victim is a stakeholder in a crime, that means whether he has a right to participate at all stages of the trial.
Uh, Yes, sir. The victim is a stakeholder of a crime because he was the first person to whom the crime exactly has been apprehended, and secondly, there are different segments where this part of victim has been taken place. Like for example, TI parade. In the investigation process, also victim can take parts.
Something is content in a law book. Like, let's take an example. Avatar Singh is one of the finest author of contract, and he has written something in his law book of contract. Whether that is relevant in the court of law.
Sir, in terms of citations. Avtar Singh, MP Jain. These are some persons who are considered to be authoritative. So, if those persons whose writing is to be considered as authoritative, then it can be taken into consideration, sir.
So you're saying that if I write something in a law book, whether that will be relevant because I'm not an authoritative person, but still I write a law book, whether that will be relevant.
That can be considered for expert opinion, but it is not mandatory that it will be followed. It is upon the discretion of the court, sir.
Okay. Okay. Yes. Please tell me what is the difference between relevancy and admissibility.
So, sir, I am not able to frame it.
Okay. Okay. Whether a video conferencing is admissible under Indian Evidence Act?
Yes, sir. Video conferencing is admissible under Indian Evidence Act, sir.
Okay. What is the doctrine of retreat to the wall?
Sorry, sir, I am not able to get it.
Okay. Can you tell me what do you understand by the Hicklin's test? Hicklin's test.
He claims test. Sir, sorry, sir, I am not able to remember it.
What are the objectives? Why the PCPNDT Act, Prenatal Preconception and Diagnostic Act, was framed?
Sure, it was framed because the female feticides had increased in those era, and people were just aborting the child, and it was also held that the child or the fetus is also having the right to live, and this is the reason the separate laws has been framed for them, because IPC generally speaks about the person, and when it is speaking about the person, fetus has not been considered as person till till they're born or one part of its body has come out from the mother's womb.
Okay. Can you tell me why is Raurkela chosen as a place where SAIL established its plant?
Sir, Raurkela is a place, it has two or three factors to be taken into consideration for a steel plant. First is, it is at the confluence of Subarnarekha River and Koel River, and simultaneously it is near to the coal fields, that is Jharia coal fields, and similarly the raw material or the iron ore is also nearby, and and also the Mahanadi coal fields is also nearby. Hence, these all things make it a very good combination to set up a steel plant over there.
Right. Right. What do you teach in law college? I mean, you're an assistant
So
professor. What do you teach?
currently I'm teaching constitutional law, sir.
Constitutional law. Okay. So please tell me what do you understand by the doctrine of eclipse?
Sir, doctrine of eclipse is given under Article 13, where basically the laws which are inconsistent to the fundamental rights will not be removed, but will have an eclipse to it, that is, will be in a dormant position. That is the doctrine of eclipses.
Okay. And what do you understand by the transformative constitution?
So, transformative constitution is basically, I am not sure of it, but as of now, which I can think is that where a process, where procedure established by law is being transferred to basically due process of law. This is what transformative.
Can you just tell me the difference between constitution and constitutionalism?
Yes, sir. So constitution is the basically a draft which a particular legislature or a country frames for itself, to which it will be governed. But there are some kind of spirits attached to the constitution which is to be taken into consideration for the upbringing of the person, or sorry, upbringing of the society and the citizens, for the well-being of democracy. The spirit for which this constitution has been written is constitutionalism, sir. Every country may have constitution, but not all country may have constitutionalism, sir.
Okay. Okay. Thank you, Anshuman. Fair enough. Let's now proceed to the feedback. Okay.
Right, sir.
I
Yes, sir.
have no problem in the mannerism. Just probably I would like your hands to be a little still. Okay.
Okay,
Uh,
sir.
you move. Like I know the habit of a lecturer that will come on, but
Right,
then at least in an interview you make sure that you make this hands folded and keep
right,
it
sir.
on your legs. Okay,
Right,
and
right,
then just a little bit apart your legs should be there, and you stay still and try to answer. Okay,
right, sir.
that
Right,
you
sir.
practice. Okay, because a lot of hand movements might not go along, I mean, very well with the high court judges. So
Right,
that
sir.
please keep that in mind. Other than that, I don't have any problem with your mannerism, or I think it went decently fine. Yes, some questions you couldn't answer when I asked about general knowledge, Raurkla, everything that you could answer properly. AI and its role in research, that also you could answer properly. But I see some weakness when it comes to constitution. Also, there is no problem whatsoever. But I see some weakness in the criminal law. Like you could not say the the evidentiary value of a case diary,
Yes,
and you
sir.
could not mention the set off in CRPC, that is 428 of CRPC. Okay, and then you also could not say doctrine of retreat to the wall. That is, private defense says that once first you have to retreat to the wall, and then if you can't, there is nothing
Right,
behind you.
right, right,
Then
right, right.
only
Exactly, exactly, sir. Exactly, sir.
then
Yes.
only you can exercise
Yes,
your right
yes,
of
yes.
private defense.
Yes, sir.
Okay.
Yes, sir. Apprehension should be there. Yes.
Yes, and Hicklin's test. Hicklin's test is a test to determine the obscenity. Obscenity, which says that yes, if
Exactly.
if it is appealing, not appealing to the larger portion of the society, then that will not be considered obscene.
Right, right, sir.
Okay.
You are taught this. I forgot that.
Yes, and I think yes, there is some yes, and also I think your answers is a bit lengthy sometimes because it's okay to explain it where it is needed, but sometimes like when I asked evidentiary value of the I mean the case diary, because you did not know, you started explaining me what is the case diary. That will not go in your favor. So yeah, if you don't know, you simply say, "Sir, I do not know," and you retreat to the wall. That will be the best way.
Right, sir.
Okay,
Right, sir.
don't say, "Sir, I plead ignorance." That would be the best way to go about it. My answer. Or if you want to bluff, also then also seek permission. I may not know, but may I be allowed to try? That also you can say. But without knowing if you bluff or without taking permission if you bluff, then it will not be taken nicely.
Right, sir. Right,
Okay.
sir. Right, sir.
Other than that, you're doing well, but yes, please revise and re-revise criminal law and civil law, the core subjects like CPC, CRPC, evidence, because I don't see that you will face any problem in constitution. But if they touch CRPC, CPC, or IPC or Evidence Act, sometimes it will be a bit tricky for you. So please, there you have 14, 15 days now. Take your time and revise
Yes,
them
sir.
properly. We'll keep meeting in between. We'll do three more mocks in between as well.
Definitely.
So this was impromptu, just to check and just to make sure that yes, now you'll finally wake up, and this is a wake up call. Take this as a wake up call and start revising. Okay.
Right, sir. Right, sir. Thank you. Thank you very much, sir.
Thank you, Anshuman.